Good morning, everyone, and welcome to today's webinar on Introduction to Intellectual Property Protection in China. This webinar has been organized by the China IPR SME Helpdesk in cooperation with the Chamber of Commerce and Trade of Slovenia and Spirit Slovenia. Today's IP expert will be Mr. Jörg-Michael Scheil, and I am Alessandra Capiglia, Project Executive at the China IPR SME Helpdesk, and I am your moderator for today. So I'll be introducing to you the China IPR Helpdesk. Later, the Chamber of Commerce and Industry of Slovenia will share a couple of words about their program. But then the real protagonist of the day will be Mr. Scheil, who will share his expertise on IP protection in China. After his presentation, there will be a Q&A session. Now, a couple of words regarding the platform in case some among the audience are not familiar with GoToWebinar. There is a little chat box on the right side of your screen. Please use it to write down all questions that you might have regarding IP protection in China. Once again, after Mr. Scheil's presentation, we will have a Q&A session, and all questions will be addressed during that moment. If we don't have enough time to address all the questions, we will get back to you via email. So allow me to spend a couple of minutes on the China IPR SME Helpdesk. In a nutshell, it is an initiative of the European Commission that dates back in 2008, when the European Commission realized that a lot of European companies didn't have an understanding of the complex legal framework of IP protection in third markets, especially developing markets. So the role of the help desk is to provide jargon-free, digestible information and tool to support European companies to make informed and strategic decisions on their intellectual property protection in China. When I say China, I don't not only refer to mainland, but also to Hong Kong, Macau, and Taiwan, each of them having a different legal framework. In the last 12 years, we have assisted over 100,000 SMEs, not only from European Union, but also from potential future member states such as Turkey, Serbia, Bosnia and Herzegovina, and so on. So in concrete, what we offer is an Enquiry Helpline, which is a practical address, email address that I will share with you at the end of this webinar. European companies can email to us with all their inquiries about intellectual property protection in China, and our IP business advisor will provide free initial advice. And of course, all questions are treated confidentially in accordance to EU data protection guidelines. We also organize many training workshops and webinars like this one. Well, we used to do it physically, but now we moved online. We hope to resume physical events soon. These trainings are either a general overview of IP protection in China, like this one, or more industry focused. We also run a blog where we publish articles provided by our IP experts on the latest regulations on IP in China. And also our website is full of material like guides, regional fact sheets, infographics, e-learning modules, and so on for for all companies actually to access for free. These are two examples of material that we have on our website. On the left side, you can see the IP fact sheet of mainland China. It is a general overview of the legal framework of IP protection in China. And you can see on the right side an infographic about trade secret protection in China. There are similar initiatives as the one of the China IPR Helpdesk for Latin America and Southeast Asia regions, but also for European region. If you are interested in getting in touch with them, let us know. And of course, to all intermediaries that are attending today the event, feel free to reach out to us to explore how we can support your the network of your company. Now I'll give the floor to Petra Ardzencher, I hope the pronunciation was correct, consultant at the Chamber of Commerce and Trade of Slovenia and EEN coordinator. She will share with you a couple of words about her program. Petra, please unmute yourself and I'll give you the floor now.
Yeah, thank you, Alessandra. Ladies and gentlemen, dear participants of today's webinar, it's my great pleasure and honor to address you on behalf of the Chamber of Commerce and Industry of Slovenia. At the very beginning, let me thank you, Alexandra, and your colleagues for giving the initiative and full support of today's event. My thanks also go to the public agency Spirit Slovenia, which financially supported today's event. Last but not least, I would like to thank you today's speaker, Mr. Jörg-Michael Scheil, an expert in the protection of intellectual property in East Asia, as an invited speaker who will present interesting topics in this field today. Of course, the volume of Slovenian exports to the markets of East Asia cannot be measured by the volume of imports. However, the fact that in 2019 almost 600 Slovenian companies exported their products to China, more than 260 to Hong Kong, and more than 2,000 to Taiwan indicates how important it is that export-oriented companies are familiar with the right approach, but also possible problems that may show up in case of non-compliance with the rules in this area. And what is even more important, how to act and whom to contact in case of violation of these rules. Let me add that this webinar is the first out of 3 that the Chamber of Commerce and Industry of Slovenia, together with the public agency Spirit Slovenia, and in cooperation with the IP Helpdesk, agreed to organize together. The IP Helpdesk, you see the slide on the screen, is a service initiative of the European Commission and supports cross-border SME and research activities to manage, disseminate, and valorize technologies and other intellectual property rights and IP assets at an EU level. The European IP Helpdesk provides the following services. All of them are offered free of charge: helpline, newsletter, bulletin, online library, training, and events. As already mentioned, today's webinar will be followed by 2 more in the first half of the next year. The first will target the Southeast Asian region and the second, the South America. Finally, I would like to thank everyone who signed up and is attending today's webinar. Quite impressive number of participants shows us that this topic is of our common interest. I wish you a successful day and stay healthy.
Thank you very much, Petra. Now, without any further ado, I am very happy to introduce to you Mr. Jörg-Michael Scheil, our IP advisor for today. He is partner of SMB Law. Mr. Scheil, I will give you the power to control my slides in a second. Welcome to our webinar, and once again, thank you very much for being here with us today to share your expertise on IP protection in China. Once again, to the audience, feel free to write down any question you might have regarding IP, and we will address all questions at the end of this session. Michael, the floor is yours, and thank you again.
Okay, thank you very much for your introduction, and good morning to all participants from Slovenia and anywhere else in Europe. And I'm very glad to share with you today an overview of some of the basics of protecting your IP in China, and also some recent developments which are going on. So we will first look at, after an introduction, we will have a look at which kinds of IPR are available and how to acquire those rights. We will look at e-commerce, which might be quite relevant for exporting companies. We will have a look how IPR rights can be protected at trade fairs, where they are normally quite vulnerable. We will have 2 case studies, one about a design patent and one about a trademark case. And we will end up with a few summarizing best practice guidance recommendations. So when we talk to our clients, we often hear a lot of skepticism about IPR protection in China, especially, let's say, from those companies who are relatively new to the game. And some people will say, is it really worthwhile to invest into IPR in China? Someone told us it looks good on paper, but it doesn't really work in real life. And especially when someone is really infringing your rights because you are a foreign company, you will never achieve, or you will never obtain actual and equal standing in the courts, and you will never really have proper protection. We will talk about this through the entire content of the presentation, and we will see ultimately that the, let's say, general prejudices are not really accurate. Here you see a table of the different kinds of IPR which are available in China, and with a reference to the basic piece of legislation governing those rights. So coming from Europe, this will not be very surprising for all of us. As you can see, the basic types of IP rights which we know are actually also available in China. So there are patents, utility models, and designs. They are jointly called patents in the Chinese patent law. So all three types of rights governed by one uniform law. There are trademarks plus geographical indications. There are copyrights protected by a separate copyright law. There are domain names, of course, plant varieties, special regulations about integrated circuits, and the concept of trade secrets is also known in Chinese law. So basically, it's a complete system. And another thing that you can see here, and I move to the next slide, there is a lot of things going on. Several of the basic laws are under revision or have been amended recently, and the new laws have already entered into force or will enter into force soon. So, for example, the patent law. It has been under discussion for many years, starting in 2015, and there were several drafts, and now finally it has been promulgated, and the new version will enter into force next June. It's not a revolutionary new law. It is more evolving some features which have gradually developed in practice over the years, have been basically codified into the new law. Then there is a new copyright law, which will also enter into force next June. There is actually also, leaving the boundaries of IP as such, an entire new civil code in China, which has been in the making for a very long time. Before, we had separate parts of the civil law, for example, a contract law and a property law. And now everything has been finally combined into one unified civil code. Of course, the civil code is mainly relevant for contracts, but there are some impacts on IP protection as well, and some interesting things. For example, let me just mention that data protection and personality rights are also defined in special chapters in the new civil code. And then, apart from laws enacted by the National People's Congress of China, you also see that the Supreme People's Court, China's highest court, quite often becomes active in IP. So a court, of course, cannot legislate, but different from other countries, the Chinese SPC can and will issue general guidelines or opinions, sometimes also called interpretations or judicial interpretations. And those interpretations will be binding for all lower level courts. So therefore, when it comes to many, many details of IP protection, apart from the basic laws, the SPC's interpretation are quite important. Looking at some cross-border developments or international treaties, I've just listed a few here, which affect EU participants, and you see that there is a new treaty about geographical indications, which will, I think, also be relevant for some European exporters and brand owners, and also companies engaged in food manufacturing and export. And there are also some pilot programs between the patent offices who are now engaging in more exchange and cooperation, which I think is good to see. Moving back to the domestic Chinese legal system, when you want to enforce IP rights, patents or trademarks, previously you had to go to the general courts, normally to the so-called intermediate court at the place of the defendant. So when you wanted to sue a Chinese competitor or potential infringer, you had to go to the intermediate court at the place where this company is incorporated. Then, since 2014, China has established IP courts. It started with Beijing, Shanghai, and Guangzhou, and then some more courts were set up over the years. And since 2019, we also have a final appeal IP instance established at the Supreme People's Court, which will be quite useful because otherwise the jurisdiction between different areas would not be, very unified. So how does a procedure in an IP court normally run? Here I have broken it into 8 steps just to give you an idea. There are some things which are similar to other countries and a few Chinese particularities. When we talk about injunctions later, so I leave out the injunction part right here. One thing is there is normally a pre-hearing in the Chinese IP courts, where before it's normally 1 day before the actual hearing very often, and the representatives and attorneys of both parties will mainly exchange evidence. So each side will produce their evidence and give the other party a chance to review and comment on the evidence, and then say, we accept this evidence as authentic or not. So this will then influence, let's say, the fact basis on which the court will base its decision. And it will also affect issues of burden of proof, obviously. Then the hearing will follow. Normally, hearings in the Chinese courts are very strictly structured. So the judge, the presiding judge, will always invite one lawyer to speak for a certain time, and then normally cut him or her short and give the word to the other party or ask very specific questions. So it's very structured, and there is not so much like very scripted, if you want, not so much free exchange of arguments. Then judgments will be issued, and appeal can be filed to the IP tribunal of the SPC. What are the main advantages of having IP courts? Well, they are fairly quick compared to patent litigation, for example, in some European countries, including Germany, for example. Between 9 months and 2 years is not too bad. It's fairly quick and it's efficient. By the way, this is also achieved by giving the parties short deadlines. So especially if you are ever find yourself in the position of a defendant in an IP litigation in China as a European company, let's say you are in Slovenia, and someone is serving an IP infringement action on you, or let's say on your Chinese subsidiary, you will find the reaction times are brutally short. 2 weeks, and you have to organize everything, and everything is in Chinese. You have to reply in Chinese, so to organize this is very challenging. Right, there will also be technical people involved in the IP courts, and the judges are IP people. So they have either a technical background, or they have at least a very thorough understanding of IP laws. And this is different from before, when you had general judges in the ordinary courts, and sometimes, especially for patent cases, it was, let's say, challenging. So you see here, there are some guiding opinions how to use technical investigators or technical experts, and also there is a system of typical cases, or also so-called leading cases in China. Still in China, not all court judgments are published, but more and more. The proportion of cases which are being published has increased enormously over the years. And so now actually you can research, and we often do that when we want to establish the court practice and precedents. You can research into Chinese IP court judgments, which is very good. When you want to get deeper into some questions, those top IP cases or typical IP cases or leading cases are very noteworthy, and normally give us an idea which kind of principles are firmly established and accepted in all the Chinese courts. Evidence is normally a crucial issue in every IP dispute in China, because very often, as a foreign party, you know fairly well that you may have been treated badly, or that your rights have been infringed, but you may not have all the evidence ready, or you may not have all the evidence ready in the right form and in Chinese. The formal requirements for evidence were a hurdle for many companies to really get their rights properly protected. Also very often in trademark cases, when you, for example, had to prove a certain market influence or reputation of your trademark in China. And when companies want to do that by proving sales, it often turned out quite difficult, because there was no formal contract, or the documentation was even not available anymore after many years, or the actual trademark was not really shown on the papers, and so on and so on. So many issues regarding to evidence, and many a case where right holders feel, oh, we have a good case. And then when you analyze it, you say, yes, you might have a good case, but the evidence is very, problematic. The Chinese system has somehow recognized that evidence is a problem, and so there are new guidelines by the SPC, effective just since basically half a month, and which make life a bit easier for European patent owners or trademark owners. Especially submission of foreign originated evidence will be facilitated. There will not be a strict notarization requirement for all kinds of evidence anymore when you want to bring it to court. Before, everything had to be notarized. Courts can assist in evidence preservation on behalf of a claimant in some situations, and in some other situations, a reversal of the burden of proof will apply. So basically, especially for process patents, you have to provide what we call prima facie, or first plausible evidence, and then basically the defendant has to provide counter evidence. So that makes it much easier to get your claims through. Right now, a few highlights regarding the new patent law, which I mentioned before. So one thing, punitive damages are introduced for the first time for infringements. So normally we know punitive damages from the US system mostly, and China was always more oriented to Europe, and let's say not using those punitive or excessive damages which we know from the US system. So before, when even you were winning an IP infringement case in China, the damages were very limited. Sometimes companies said, well, it doesn't even cover our costs, you know, because to be honest, I mean, IP litigation is never cheap, but in China, the average cost is probably not really below many European countries, because due to the evidence requirements and so on, the amount of preparation work and effort you have to put in is really quite substantial. So it's a very good news to see that the damages are going up, definitely. We see more cases with significant damages awarded by Chinese courts, and also the statutory limits are raised. Then there is something moving on design patents. China is preparing to join the Hague Agreement, and so the protection period is increased to 15 years for design patents. A system of open licenses is introduced where you can basically notify the patent office that you are willing to license to the broad public under some conditions. There are some developments for pharmaceutical companies. I don't know whether we have any participants from those industries here today or not, but a patent linkage system will also be introduced, and some other developments for drug patents. Then the authorities of the IP administration to handle patent infringement cases will be enlarged. So apart from going to court in China, you can also turn to the patent or IP bureau and apply for protection of your patent or trademark rights in a local IP bureau. The competences of those local bureaus are now increased. And then there is also a general good faith principle introduced into patent applications. Right, so artificial intelligence is definitely a very important topic in patent protection right now in many countries, and China has also been looking at this topic. In the new patent examination guidelines, there are some clarifications how and under which conditions artificial intelligence can be patented. So first of all, an artificial intelligence system itself cannot be named as an inventor in China. Many of you will know that in Europe it's also very much under discussion. But China is currently saying no. The inventor has still to be a natural person, a human being. Then there are some other guidelines regarding, for example, so-called business rules and methods. This is also different between US and Europe. Europe is more restrictive. In the US system, as far as I know, business rules and methods can be protected more easily. And China is more close to the European approach. So I have two examples here. One patent, a method for application of shared bicycles, was patented. Main reason, it includes not only algorithms, but also a basically interaction between certain physical devices and the bikes, of course, and the algorithm. So it's embodied in some kind of physical device, and so that was deemed patentable. And someone else had a good idea how to analyze the state of the economy by looking at electricity consumption. Well, it's definitely a good research approach, but unfortunately, it's not patentable. Yeah, it's a pure computer executed abstract method, and so this cannot be patented in China. Right. I suppose that many of you might potentially face trademark issues in China for all those companies who trade in China, who source potentially also from China or export to China. I think or provide services in China. Trademarks are normally an important concern. So here we also have a law which is relatively recently amended. And apart from the fact that here also the statutory awards have been raised significantly from 3 million RMB to 5 million RMB. Yeah, so that would be something like 600 plus something thousand euro. Apart from that, there is also some new regulations on bad faith applications, and this happens a lot. You know, maybe some of you have been affected by this problem. You want to enter the Chinese market. You have not registered your trademarks yet. You have other international trademarks registered in Europe, in Slovenia, maybe even in Japan or in Korea, but for some reasons you have not registered in China. And then you do a trademark search and you find that someone has registered some trademarks which are either identical or very, very similar to your marks, maybe even in the same classes or adjacent classes with slightly different list of goods, or in some other classes. And then you are very shocked to learn that, and it might mean that your application will be blocked, you know, because it would collide with these already established registered Chinese trademarks. And then when you look at who has registered our names, right? Then you find it's some people who are not even in the business. They are just basically collecting trademarks. Some companies or individuals have hundreds of trademarks which are relatively well known somewhere else, but have not been registered in China. If you have such a situation, well, the message is the new trademark law gives you more options to fight against those bad faith applications. So it may be very worthwhile to check it case by case. It depends on, you know, bad faith, for example, is assumed when the applicant has been in a business relationship with you before. For example, someone talked to you and said, "We want to be an agent for your products in China." And then you said, "Well, we can try." But after all, at the end, it didn't work out, and you maybe terminated the relationship. But maybe then this is a reason for this agent or for someone who has known about your product to say, "Oh, but we might grab the trademark. You know, that this may be good for us." So that can be bad faith. And another condition is that your trademark has a certain reputation, or even better, if it's a so-called well-known trademark, then it will be the protection will be better. But conditions to be recognized as well-known trademarks are very high in China. There is also wider options, for example, to request courts to order destruction of commodities bearing counterfeit trademarks, and also the tools. So that might be very good if you can, in order to prevent future production of the same goods. Okay, I move to trade secrets. Here, trade secrets are governed by the anti-unfair competition law, and it is also out in a new version, basically same time as the trademark law. So the definition of trade secrets has been broadened, which is welcome. Not only limited to technical and business information anymore, but all trade information. And here the same trend which we see for some of the other types of IPR rights also happening here. Higher statutory penalties available and facilitations for proof. So it's moving in the same direction, and which is very good. But I have to say, protecting trade secrets still is very difficult. The typical case is probably you have a company or operation in China. You have this very, very talented sales manager who has generated a lot of turnover for you over the years. And now he or she is leaving and joining a competitor, taking the client list, taking maybe even some technical recipes of your product, and so on and so on. Yeah. So and then you may sue either and/or the former employee or his new company under the trade secret regime. Yeah, so that's the main application which we see here for trade secret protection. Okay, and there are some other amendments as well, and even it may be a criminal offense. Just to keep in mind as basically an ultima ratio, if it's a very, very serious case, criminal action can also be initiated. For copyrights, we see some developments here that audio visual works are introduced as a new concept, obviously to include things like live streams and video games. And the same tendencies which we have seen before also here, higher damages and easier evidence and proof rules. Okay, E-commerce is obviously a very hot topic when it comes to China, and the market is very large, and the Chinese e-commerce platforms are working very well and generating huge turnovers. But everyone who is familiar with this also knows that a lot of IP, let's say, problematic products are also offered on those platforms. And many European companies find products on Taobao or somewhere, where you say, oh, this is our product, or it's very, very similar to our product, or they are using our trademark. So the good news here is that, yes, there is a regime in China how the platform operator will be jointly liable under some situations, and how you can demand a takedown, right? So there are also some guiding opinions by the Supreme Court. And the main condition on which it all depends is if the platform operator should know that an operator doing online business over its platform involves infringement on intellectual property rights. So, and then there are some rules and procedures how to request, how to notify the platform to provide some, for example, your trademark certificate or other evidence of your IP rights. And then there will be a takedown. It's good to keep this in mind, if and maybe to keep also watching what is happening on some of these platforms. Right. I mentioned before trade fairs. Some of you may have participated in trade fairs in China, or maybe you want to do that in the future, when normal traveling is hopefully possible again. Once again, similar as on online platforms, sometimes IP owners will notice some bad things are going on. You know, someone is displaying a product which is, you know, looking very, very similar to your product, or has similar functionalities. Or the trademark, the name of the company is like your company, or it's like your company but in Chinese characters. So it's very confusing consumers, and it might take business away from you. So then here the key message is, on every exhibition in China, by law, there needs to be an IP complaints office. And it's normally staffed with some people who know the law, and you can file your complaints. And sometimes there will be a kind of mediation. So the people in these IP offices, they will walk to the booth of the, let's say, potential infringer with you and try to convince them, for example, to take away some products, or to cover the logo or something like that. And if it cannot be solved on the spot, then it will be sent to the local IP bureau, and the local IP bureau should decide within 1 or 2 days. So that's how it works on trade fairs. Yeah, here you have this, and a fine can be imposed on infringers, and also, which might be serious for a good deterrent for some. If you are caught twice, then you cannot take part in the next exhibition. So this may be a good tool. Here, just a reminder which documents you will need to prepare. And basically here the recommendation is to have these documents maybe ready before the first day when you go on an exhibition. You know, so your trademark certificate, your patent certificate, and that's the basic thing. even in an official Chinese language version, so that basically then you are prepared if something shows up. You can also apply for an interim injunction during a fair or even in another situation based on these 2019 rules, which are quoted here. And it's similar to other jurisdictions. The basic condition is an imminent infringement of IP rights and time-sensitive situations such as trade fairs are recognized as one important typical case. There are also other situations, for example, someone is preparing to broadcast something on TV and you have to stop it, and so on and so on. Then interim injunctions will be considered. The local court where it happens is the one who has the competence. Right, we come close to the finish line, and we look at two case studies. The first one, which is a case that has actually happened, obviously, a manufacturer of a surgical microscope had obtained a Chinese design patent for that, and then they noticed on a trade fair, oh, this product looks so much like ours. Then a sample purchase was arranged on the exhibition, and following that, a design patent infringement case was filed at the local court. Then hearings and all this, what I indicated before, followed, and the court was clearly leaning into the claimant's direction, and also gave those signals to the defendant that it's quite likely we will find you in infringement and you will have to pay some damages. And then out of court negotiations started. They were quite complicated, I have to say, because the wording of such settlement agreements, there are some clauses which the right holder wants to have, but the infringer obviously doesn't want to have. Then there's a question of how much penalty the defendant is willing to pay. Finally, it was solved because the penalty was even a bit higher than what the claimant would have probably obtained in court. So then the case was closed successfully, and product was removed from the market, the infringing product. Here, in a trademark case, it's one of those black-face cases which I mentioned before. An EU brand owner had his international trademarks, but the coverage in China was only selected, only in some classes, not all the marks. So there were big gaps, basically. And then a Chinese trader was noticed who displayed, offered products on a platform, an online platform, under a identical trademark, but in a slightly different class. Then a warning letter was sent, but in China you will find that very, very often no reaction to warning letters. So, and then what we did is to file an invalidation request against this this other party's trademark, based on the prior use of the trademark by the trademark owner, by the international brand owner, and a certain reputation in the Chinese market. And what's more, what I have mentioned before, it could be proven that the opponent had a kind of business relationship with the trademark owner before, and that was the basis how he, came to the idea, oh, I can grab this trademark. So then, in result, the opponent's trademark was invalidated, and the road was cleared for the European right holder to basically register this trademark in China. This brings us to the end, and I would like to summarize with just a very few, I won't read all of them, recommendations or insights. So basically, what we would really recommend is to have your IP strategy ready, spend some time, consult internally and with experts before you enter the Chinese market, because that's the crucial time. And once your products are circulating in the market, then certain risks can already, arise, and you may not be in a very good position to react anymore. Of course, get familiar with the business environment in China, also with the legal environment. I hope that this presentation is a good starting point. And then register your rights, use the opportunities which Chinese IP law gives you before you start operations in China, before you go into the market. And then the last thing which I would like to mention, do some degree of proper monitoring. Watch what your competitors are doing, which IP rights, which patents and trademarks your main competitors may be applying for, and watch those online platforms. And then be ready to use the tools. Don't be, let's say, hesitant or shy, subject to case-by-case analysis, to use the tools which IP law in China, with all those new amendments which we have seen now, provides to you. Thank you very much.
All right. Thank you very much, Michael, for your very insightful presentation. So okay. Here, contact details of Mr. Michael's law firm, in case you'll be interested in getting in touch with them. All right, so now our Q&A session. We got some questions for you. Oh, there is a long one. Let me read it for you. Is protection of inventions as utility model patents, short-term patents, for short lifetime products, such as computer parts, an appropriate strategy in China? Regular patent procedures take too much time. By the time they are granted, the product incorporating the patented invention is almost obsolete. Moreover, the procedure is faster and also cheaper. Could you point out pros and cons on protection in China? Thank you.
If I understood correctly, the main point of this question is about utility models. Am I correct?
Correct. So, yeah, short lifetime products such as computer parts.
Yes. Right. Similar as in EU patent law, the patentability protection requirements for utility models are lower in China. So whereas you need to pass a full test of novelty and inventiveness for an invention patent, and there will be a substantial examination by the Chinese Patent Office, utility models only need a so-called inventive step, which is less, and there will be only a formal examination. So, and the timing is shorter to obtain a utility model. So definitely, yes, the answer is positive for short product cycles or short lifetime products, and also time sensitive. If you want to get a quick protection, do consider utility model protection, and you may even have to file a double application for patent and utility model at the same time, and then give up the utility model at a later point in time.
All right, next question. Just a little note for everyone. Yes, the slides will be shared to all participants, so don't you worry about it. Okay, next question. Regarding the registration of trademark, how bad it actually is for a company to learn that in China someone already registered the same trademark? What is the worst risk?
Well, first of all, it will affect your marketing strategy, because what you want, of course, is to offer your products or services in China under the same brands and trademarks which you are using internationally. And if you find your proper or usual names and brands blocked or not available in China, then you have to work around it somehow. For example, very crucial here is also you need a Chinese trademark. You need what I mean is a trademark in Chinese characters for your brand name and your company name. And if you will find that certain transliterations are not available because someone else has a similar combination of trademarks already registered, and you haven't thought of that before because you haven't been in China. And then what you have to do is maybe find another combination of trademark of Chinese characters, which can work well. But if your product has already been exported to China and customers already know it under another name, it may be very inconvenient. So that's one thing. And also, if someone else has registered the trademark and you are selling in the market, this other trademark owner can sue you for infringement and can ask you to stop your sales. And this is, of course, I would say absolutely the worst case. So when you enter the market, please consider to do a proper trademark availability search and also check the potential infringement risks and align your, let's say, marketing and branding people with IP experts who know China to find a good solution.
All right. Oh, wow. We're getting a lot of questions. Okay. Based on your experience, Michael, which sector is the most affected by IPR infringement in China?
Well, it's very broad. I mean, of course, consumer products come to mind first. And there are, of course, many cases of European consumer products who have been affected by counterfeiting in China, be it handbags, be it sneakers, you name it, whatever you can, and even food. But it doesn't stop here. There are lots of industrial products which are affected. We have talked to machinery builders who say someone has copied our entire machine, and unfortunately we don't have any patent on it because we thought it's not meaningful to have to spend money on Chinese patents. So it can be machinery, it can be electronic components, it can be automotive parts. It's basically the whole range, and wherever European companies are successful and well known in the Chinese market for their products, there you will find infringement risks.
All right, I think we have time for one last question. For all the other questions that we have not answered, we will follow up with you via email. So one last question for you, Michael. What are the average cost and average time needed to protect your IP trademark at Chinese courts?
All right. So okay. The question is about, let's say, an IP in a trademark infringement situation.
Exactly. That's my guess.
Okay. The time frame. I mean, the fastest solution is, of course, you send, let's say, a warning letter through a law firm, and the opponent is very, let's say, concerned of his reputation, and he will voluntarily stop. And then you can solve it in 2 weeks, and maybe the cost is 1,000–2,000 euro, right? So that would be ideal. Very often it's not like that, and the cost of a infringement, the timing of an infringement lawsuit in a Chinese court is that timing which we had for the IP courts before. You remember on that slide, 9 months to 2 years. That would be the time frame for also trademark litigation case. And the cost is definitely above 10,000 euro, but it could go up significantly. And this simply depends on the complexity of the case and the amount of investigation. Sometimes we need commercial investigations before we are on the starting line to sue someone, you know, and the cost of investigation can be significant. And you have all the document preparation, you have the translation costs. So it can start from such a figure, and it could go up to a 6-digit amount.
All right, thank you very much, Michael. I think we need to wrap up this webinar. For the audience who will have any question in the future, please do not hesitate to send us your inquiries via the email you see on the screen. The help desk will reply to you within 3 working days in a free, fast, and confidential way. Let's also stay connected. Follow us on social media to be up to date with the publications on our website and also on the events that we organize. Once again, many thanks to the Chamber of Commerce and Trade of Slovenia for co-organizing the event with us. And of course, many thanks to Michael for sharing his expertise. I wish everybody a very good day and a great weekend, and see you next time.